Important meeting about water in our valley. My name is Geroge Schneider. I've been asked by folks at our Methow Watershed Council to help moderate tonight's meeting. So I thank them for that opportunity, and thank you all for coming. I also want to mention thanks to the Grange, Swiss Grange, for use of this beautiful facility with its aromatic floor. I think that's what we're smelling. And particularly thanks to three folks from State Department of Ecology who traveled up here from Union Gap this evening to help us understand what's changed as far as water management, the rules around water use in the Methow. So I'm going to introduce Gregg Knot, who's the Chair Emeritus, or past Chair of the Methow Watershed Council, in just a second. But I did want to just note that the Grange has restrooms just out those double doors as you came in. That's also the best way out in an emergency. There's exits over here and here as well. I don't know where these go. So they go out to the cold, so that's good.
Seat belts.
The way we've organized the evening, hopefully, is to be able to convey the most information in a short amount of time to you all. We're going to start out after a few words of introduction from Gregg with a presentation from the Department of Ecology about what's changed. We're then going to, that'll take about 20-25 minutes. And then we're going to take a break for about 15 minutes, the purpose of which is for y'all to, having absorbed a little bit of what Trevor and Gregg have to say, to put down on paper questions that you have or comments that you have. Particularly, you'll get an opportunity to hear a response. Sarah Lane, who's, there's Sarah in the back, she will be the person collecting those questions during the break, and then Gregg and I will go through them and kind of organize them and present them to a panel, which will convene right after the break. The panel will consist of Commissioner Andy Hover, County Commissioner, Trevor Hutton from Ecology, and Travis Thornton. And Natalie. So Travis is as a informed and concerned citizen, and Natalie as a local water attorney. You're here till 8:30 if there are questions. And so any questions so far about what we're doing?
Would there be a time for verbal questions and answers, or is it all submission of written questions?
Well, ideally we'll do written questions. That way we can get the most, the ones that seem to have the most weight.
So you'll choose what's most relevant.
And we'll allow for some short follow-up questions.
I guess what I'm asking is, who will make the decision what's a relevant question?
I'm the moderator.
So you'll
So it's me, so you can blame me. Yeah. If there's time at the end, we've gone through all the written questions. We certainly can take some questions from the floor,
okay,
but there may not be time. So, why are we here? What has changed? Right? Did the law change? Did a rule change? Did science change? That's part of what Trevor and the panel members are going to try to convey to us tonight. Who is affected by this? Who's not affected? And if folks are affected, how are they affected? Is it positive? Is it negative? And finally, can deal with the effects. How can this be mitigated if it is a negative effect on folks? So those are some of the key questions that we hope to get answered. So I'm going to introduce Gregg Knot, Methow Watershed Council past chair. Welcome, Gregg.
Thank you for coming. It hasn't been the best weather today, but I think the roads have cleaned up just a little bit. I'm here to kind of give my usual pitch for the Methow Watershed Council. I've been the chair for the last about 10 years or so, and I decided not to continue in that position because I'm hopefully going to retire. We'll see how that works. But just to explain what the Watershed Council is it's a group of citizens. There's 9 of us all told, and we are appointed by the mayors of the towns of Winthrop and Twisp and by Okanagan County. We serve as volunteers. We're all volunteer organization. We serve 2-year terms. We meet every Thursday over at the riverbank at 5 o'clock till 7. And we encourage all members of the public to come. We have, you can contact Sarah back there, and you can get on our distribution list for agendas and notes if you're interested. What do? We have 3 basic jobs. First one is we serve as an advisory board for the governments on water issues, so that if they have questions about water or drawing on our expertise, they would come to us and we would say, well, this is what we think or this is what we know. Secondly is we serve as a voice of citizens. We all represent certain areas. I happen to represent the North Valley, and we try and talk to the community and bring those opinions back to the Watershed Council, because people like Andy sit and listen to those opinions once a month, every 3rd Thursday, Waterbank, 5 o'clock. And hopefully we can pass on what their constituents are feeling about water issues. And last, we are the repository, probably the most complete set of information on water in the valley, and probably in north central Washington. Over the years, the last 15 years of existence, we've done a job of collecting everything we possibly can about water relating to the Methow. If you go on our website, and just Google Methow Watershed Council, you will find that we have a extensive library. So if you're looking for something about water, whether it be past legislation, whether it be past technical studies, whether it be past papers that have been written about water in the Methow going as far back as we can find, you'll find it there. So with that, we welcome you all here. This is part of the role we have of informing the public, and so we feel like we felt like we wanted to convene this meeting so that we could get a very real issue to a lot of us in front of the public, and you would have an opportunity to hear some of the reasons why we are in the position we are now. So with that, I'll turn it back over to George.
Okay, thanks, Greg. So I'm going to introduce Trevor Hutton. Trevor, I believe, if I get this right, you're the section head of the Water Resource Program for State Department of Ecology. I'd like to ask to let Trevor's presentation kind of go uninterrupted. Take notes if you have a question that comes up, and that way we can get the continuous flow of good information from Trevor, and then have follow-up questions after the break.
Sure.
Okay? Do we need the lights off for you?
Can everybody see that decently well? It's going to be a little bit small for those of you in the back, but I think we've got some handouts as well. So I'm Trevor Hutton. I am the section manager for our central region. My region is the 7 counties right up and down the middle of Washington State. We deal with all sorts of water-related issues, new permitting, changes to existing water rights, implementation of rules and laws related to our water resources in the region. Just by way of introduction, I've brought with me Vanessa Brinkhouse, and she does some of our watershed planning work, and Mark Shupe, who is our Okanagan and Chelan County Water Master. So they're good sources of information. If you have questions, feel free to ask them as well. On the topic of questions, I would also say, if you've got questions that are very specific to a certain circumstance or situation that you've got on your property or with your water right or something like that, we've got some cards in the back for our customer service line, and if you feel like your question really might be a better thing to handle sort of on the side and not necessarily in the group setting here, that'd be a great way to get in touch with us as well. So just know that those are available back there if you need them. So why are we here? What are we talking about? We're talking about some changes that were recently announced in the tributaries of the Methow River that are administratively closed. We haven't closed anything new. There haven't been any changes to our laws or our rules. This is an interpretive change based on a lot of recent case decisions and risk analyses that the department's been doing. If you've been following the media, you've probably seen things about the Hearst case or water moratoriums around the state, things like that. There are, I think now more than ever, there is a bright spotlight around the issue of domestic water and wells that supply that domestic water. I'll get far more in depth on what is happening here, but I'm going to start with a brief introduction to sort of basic water law. What are the things that I and my colleagues, the Department of Ecology, need to consider as part of our water resource management structure? I'm going to talk a little bit about the Methow Basin in-stream flow rule, why that was created, what it is, what it does, and then I'm going to drill down deeper into the closed tributaries, specifically restricted areas within those closed tributaries, how that connection between ground and surface water, I'll explain a little bit about that connection. And then I want to talk about what do we do moving forward, because I know that there are probably a lot of folks here who are impacted by what we've recently said. That's a very real impact, and I don't want to dismiss or in any way negate the fact that there are folks in the audience who probably had plans that are now going to have to take a different path. So I just want to be upfront and aware that I feel you, I hear you, and we're going to continue working with the county and with the Watershed Council and with stakeholders in the area to figure out what can we do from now. We've got a few ideas, we've got some concepts, but it's going to take involvement from stakeholder groups, and it's going to take you guys as a community coming together to support ecology and the county in finding these ways forward. None of us is going to carry this alone. So just encouraging you, what Greg was saying about partnering with the Watershed Council up here. It's been a great group, and I'd say, if you have questions about that, feel free to talk to your Watershed Council folks about how you can participate and support what they're doing. So at the most fundamental level, we have water rights in the state of Washington. The state of Washington is a prior appropriation state, and I will explain what that means here in a minute, but a water right establishes a legal authorization to use water in a reasonable amount for a specific beneficial purpose. There are attributes of a water right. So you could have a right to use X amount of water on such and such parcel of land for the irrigation of 10 acres. All of those are attributes that provide compliance points and allow you to know sort of the bounds of your water right. Once you've begun using that water, you're establishing a vestige on the water right that you've been granted. So why do we need all these things? Our state's waters are a public resource. People don't get to own the water, they get to own the right to use the water. But the water itself is a public resource, and we need to ensure that those are put to a maximum benefit across the state. We, Ecology, my department, is required under the water code to ensure that water rights are allocated properly, that things are managed so that there aren't any effects to existing water right holders, because this notion of first in time, first in right, prior appropriation, I've got another slide on that here in a second. But that's the last point here too. These priority dates, the date that you've established the water right, creates a system of seniority. If you're older, you have a right to use your water to the exclusion of somebody who's more junior to you. So a newcomer doesn't have the same protection and availability as you would as the holder of an older water right. In addition, the stream flows that are set in rules across the state also carry with those a priority date of the date of the rule. So it essentially creates a water right by extension that holds the priority date of that. So anything that is junior to the priority date of that rule, that in-stream flow, would be curtailed anytime those in-stream flows aren't met. So our water code goes all the way back to 1917. The state decreed at that time that all waters within the state belong to the public, subject to existing. Ecology has been previously the Department of Hydraulics and other agencies in the past. Now we're Ecology, and we are the ones who facilitate new water right changes, etc. In 1945, the legislature decided that it would be appropriate to extend the surface water code to groundwater. It again created a permit system for new uses of groundwater, except it did a very important thing. They created a special category of permit-exempt uses that are defined in statute for domestic and industrial purposes up to 5,000 gallons per day, irrigation of half an acre of non-commercial water garden, and water for stock. I'm not going to read everything on this slide, but this is just to kind of demonstrate that a lot has changed over the years. So from 1970 to present, these are sort of the major changes in water resource related law. I'm sorry if I'm standing right in front of you. You know, there have been a number of things that have changed, and as you can probably guess, you know, things have tightened up over the years. The ability for ecology to make decisions has become more and more scrutinized. And so we see this manifesting in all these different pieces of legislation that come through and sort of change the game every time, just a little bit. A requirement to do an evaluation on 4 things. We need to know that the water use will be beneficial. We need to know that that water use won't cause impairment of existing water rights or impact their ability to get their water. We need to know that there is water available in the system, physically and legally. And we need to know that when we issue that water right, it's not going to be detrimental to the public interest. And we have tools, and we have, you know, in our report writing, we document all these things as we make a water right decision. Now this doesn't apply, for the most part, if you are putting in a permit-exempt well. Ecology typically, in most places in the state, doesn't look at a permit-exempt use the same way as we look at a permit. And over the years, the last few years specifically, we've seen that the courts have moved steadily towards saying that, you know, somebody's still got to look at that, and, you know, counties across the state, you are now tasked and responsible with making a finding of water availability when you're approving a building permit or a subdivision. You know, there were a number of key cases over the past few years that established that, and really it's, you know, that was the gist of the Hearst case. You know, that was sort of the most recent statement by the court system to say, yes, it is the responsibility of the counties to do this. And so now I want to talk a little bit about the Methow Basin in-stream flow rule, and we're going to get back into how that relates to permit-exempt uses and what you're going to be faced with as you're trying to develop a new use somewhere in the basin. The in-stream flow rule was originally developed in 1976. That followed a local watershed planning process. There was quite a bit of community outreach at that point. Participation, there were surveys sent out, there were meetings, and that produced the Methow Watershed Plan, which I'm sure the guys at the council would be happy to talk to you more about if you have questions about the plan itself. That led to the adoption of the 1976 Methow Basin Rule. That rule was then amended in 1988 and 1991. The intention was to help find balance between the competing demands. Now, this valley has a lot of, there are people who would probably like to see this valley different in every way you can imagine. More agriculture, less agriculture, more development, less development. Everybody's got their own opinion on that, right? So the rule being a publicly the public had an opportunity to put their voice into this process. It was intended that this rule capture that and establish for the basin a set of guiding principles and rules that would help balance these competing demands. The other things that it did were it established minimum in-stream flows for all the various reaches that are identified in the rule. It established a hierarchy of use, meaning that the rule set aside certain quantities for certain purposes to be considered senior. Single domestic and stock watering were given their own sort of super priority to say these are more important than even the stream flow. So if flows dip below the minimums, these uses, single domestic and stock watering, aren't curtailed. Everything else is. The other thing that it did, importantly, is it closed selected tributaries. And it did that because at the time, these tributaries had gone through an adjudication process, and that's where a court comes in and says, you know, they define for folks the priority and quantity that folks can use water in the basin. So several of these small tributaries were adjudicated or in the process of adjudication. And at that point, when the rule was created, it was decided that ecology had found that no further water was available for consumptive appropriation in the basins. And that was done to protect existing water right holders, to protect existing landowners who had developed a reliance on the water and wanted to make sure that it was going to be a resource that they could use in perpetuity. So, that's sort of the global picture of the in-stream flow rule. I'm not going to talk much about the in-stream flows or the use priorities. Those are certainly good topics to talk about, but I'm going to focus specifically on these tributaries that were closed. The rule lists out which tributaries those are, and there's streams and lakes that are considered closed to all further appropriation. In 1991, ecology, as something of a follow-up to the 91 amendment, began a process of having our hydrogeologists come out to the area and evaluate these areas. And what we concluded back then was that in the upper portions of these closed tributaries, kind of above the main Methow Valley floor, we concluded that groundwater from the shallow sedimentary aquifers was in high confidence connected to these closed streams. And so the change in 1991 to include groundwater was backed up by the fact that we now had some science saying, yeah, we kind of know that in these areas, and if you've been following this, these are the areas that for a long time were just kind of termed the closed basin maps. If you've seen those, you'll know that they kind of stop before they get down to the very last little piece, sometimes part of a mile up to a mile, a little bit more than a mile on the main stem valley floor. In these areas, we concluded, yeah, the shallow aquifers there are connected, so we can't allow any wells to be drilled that would tap into that already over-allocated resource. For many years after that, we then decided that the well construction in those areas could be allowed if wells were drilled deeper down into the bedrock formations. And we did that because we understood this need for flexibility in allowing rural development and wanting to also be cognizant of a resource. So we felt like at the time we had a pretty good balance point there of being protective of the resource while also having the ability to have folks develop these rural properties. In more recent times, we've seen case law and we've seen litigation has really changed that. To the point where ecology in other basins in the state has created rules, and people have developed based upon those rules, and then the court has gone in and said, oh yeah, all that stuff that was just developed is now illegal. It's getting pretty tight. You know, the standard of proof, the burden of proof to show that you're not having an impact, even de minimis. There's no such thing as a de minimis or allowable impairment of an in-stream flow. And so that's really tightened up over the years. But what we want to do is we want to manage in such a way that we protect stream flows and we protect existing users. Because remember, we have an obligation to manage on a first-in-time, first-in-right basis. So if you're that person who is already in an area using water, we have an obligation to you to make sure that your situation doesn't get worse by allowing more wells to go in, by allowing new water rights, etc. If you're the person that tries to come after, you're probably not going to be very happy with the answer, because we can't allow that. But that is one of the core central tenets of Western water law, is that a newcomer cannot harm somebody who's already there with an existing use. And so that's what we're trying to do here, by implementing in such a way. Some of the cases that I'll talk just briefly about, the Postuma case, this kind of set up the one molecule impairment standard. And there was a lot to this case. I'm just going to sum it up in basically one sentence to say, the court told us that if even one molecule was removed from a basin with an in-stream flow that wasn't met, that was impairment of that in-stream flow. And you didn't have to definitively show that that one molecule was leaving. You just had to basically have enough proof to say that you couldn't disprove it. That's sort of my commentary on that case. The Hearst case, more recently, it established that counties do have this obligation or responsibility as part of their land use actions to ensure that water is legally available for those uses. We do this again for a couple reasons. I want to just continue to pound this home. We have this obligation to protect existing users. That's existing homeowners who are already, living in these areas. That is the folks with adjudicated rights in these basins that were already established. And I know that this might seem a little strange, especially if you're affected by this, but we're trying to protect prospective homeowners and people who would build on a lot with the assumption that water is legally available. Because like we've seen elsewhere, we don't want to continue to allow something that is legally risky and legally vulnerable if the chance is an appeal of that decision at some level could end up negatively harming that person and perhaps other people around them by saying, yeah, that's not legal, and neither was all that other stuff. So, we really felt like this was a point where we needed to make some changes in how we manage and administer the Methow Basin rule, especially in the restricted areas of the closed basins. So to that end, you've got with you, I think there were a bunch of copies back there. Hopefully there was enough for everybody, or you've maybe already seen this if you're here. This is a letter that I sent to Okanogan County in December, basically laying out what's going on. And we have been working with Okanogan County for years now. I mean, it's been a while. We've been kind of working our way, processing our way through all this stuff, and there's a lot of complexity and there's a lot of real thought that has to go into these decisions. But this is the letter that I sent out. It outlines sort of the changes that we've put in place and why. But I understand that in a bureaucratic letter from one government to another government, there's a lot that doesn't carry over in translation. So that's why we wanted to come up here. We wanted to talk with you guys and help clear up any confusion about what's going on. I want to talk specifically about the areas that are affected, the so-called restricted areas. These are the areas where we believe that well drilling and well use will have an effect on closed surface water bodies. This map shows the outlines. So anything colored there is the watershed boundaries for the closed tributaries. In green, those are all the publicly owned lands, and in blue, those are privately held lands. And so, I'm not putting this up here to in any way diminish if you're one of those owners of a blue parcel, but just to illustrate kind of where that is affecting. We see it kind of in the lower areas of a lot of the tributaries, little bands that go right along the creek. As you get farther up the hill into the upland areas, there's more and more public ownership.
Could you provide a little bit of context, like point to a town or something?
Sure.
I mean, what watersheds are those three
Here's
blue
the
ones?
terrace.
Okay.
It's Twisp and Winthrop.
Can you name the three blue watersheds at the bottom there? Where, right there?
Down here.
Yeah.
I point to my county helpers to help me with that.
We have French Creek, Cow Creek, Gold Creek. There's 15 of them. They're actually in the in WAC 173-548 050, right?
Yep.
050 gives you the listing of the tributaries and lakes that are closed, and then the actual boundaries of the watersheds are. Do we have that on the watershed council? So on the Watershed Council's website, there are boundaries of the actual watersheds.
Sorry, I'm going to try to not lose my voice. I've been getting off a cold for a few days. So the rule requires that ecology determines, in order to allow new wells in these restricted areas, we have to make a determination that each well would be reviewed for hydraulic continuity and not have an impact on a closed surface water body. As I said, it's unique in that each well was required to get this approval from ecology in these restricted areas in writing prior to construction of the well. It's done differently in other areas. Other areas of the state, the well driller or the homeowner would file a notice of intent to drill. They'd wait the mandatory period, and then they can start drilling. This was different. We required that folks get express authorization prior to constructing any well in the basin. Once that was done, we required that that well log be reviewed to establish whether or not we believed that that was in hydraulic continuity with the closed stream. There's no other rule in the state that I'm aware of that requires that same look be done for a permit-exempt well for domestic use. You stack on top of that the fact that in these restricted areas you really have some pretty complex geology. That affects a couple of things. It affects whether or not that well is in continuity with the stream. That means the water molecules transferring physically between the stream and the well through cracks or through the aquifer. It also has a larger implication in terms of legal water availability. Water that is destined to recharge these aquifers, if they've been pumped and created this void space, that water's got to come from somewhere. It's going to come from in the basin, and it's going to take water that otherwise would have discharged to a stream, which is closed year-round to protect existing users, senior water rights from additional impacts. Just by way of anecdote, looking back at the last 10, 11 years of our records, we've seen an average of about 3 of these wells in these areas specifically per year. Sometimes it's more than that, sometimes it's less, it could be 8, it could be 2, but over the 10-year span, the average is right around 3. I'll talk a little bit more about the technical side of things here. And this is very cartoony, and this is not what underground looks like. But I want to illustrate a couple things with this slide. So in its natural state, and again, this is the more likely than not scenario. I'm not saying that this is without a doubt 100% every single piece of land in these areas. I'm saying for the level of certainty that we need to make our decisions and to advise the county to make their decisions, here's how we see things in the general sense. At the bottom, we'll say this is the natural state. You've got a creek there at the bottom. This is kind of a cross-sectional view. Hillsides going up from the creek. And you've got fractures in the bedrock. And those fractures, they take water. And in a normal state, there's probably not a lot of water leaving those fracture systems. And so springtime, the snow starts to melt, water starts to run off. Water would go over these cracks in the earth and discharge to the closed stream. So if you look at the top, that's what happens. There's a couple scenarios there that I'll talk about. This is what happens when you start drilling wells and start using water in these areas. On the left is a situation that we would consider to be hydraulic continuity. So in this picture, we've got somebody using water from their well in their house. It's drawing down the available water in this fracture system. And that fracture system might be very complex. It might be all woven underground. And you actually end up, by pumping that well, you end up inducing flow through these fractures to refill that void that gets up, into your well, into your house. You reduce the water that is in that creek through hydraulic continuity. A similar instance would be, and we didn't depict this one, but say this house was up here, and instead of actually drawing water from the creek, these fracture systems discharge to the creek. In that case, you're taking water that otherwise would have discharged to the creek, and the creek is closed. On the right, let's assume that none of these cracks, none of these fractures in the bedrock actually connect to the closed stream. So that was sort of that's kind of the bar that we looked at for quite a while. Does it physically connect or not? Do you have coincident water levels? Those are the types of things we were looking at in the well log reports. This is a different scenario. And this is, what this would be is, let's assume, again, none of these fractures connect with the stream. Well, then I can't have any effect on it, right? No. The reason being, if you begin to pump this well that's completed into one of these bedrock fractures, you have created space in that bedrock fracture aquifer. There's a gap there where there used to be water. And what's going to happen is during the spring freshet, during the year, whenever water is available to hit those recharge zones, that water is going to infiltrate preferentially to these cracks, and that is going to have an impact, however small that might be, on water that otherwise would have gone to a stream that is closed. And so that's that one right there. I mean, I think you could probably talk to a lot of technical experts, hydrogeologists, and you guys could probably, there you go. You could argue about all this stuff for a long, long time, about whether or not it is or isn't connected. And those are great conversations to have. They're fun for some people. But to me, and in terms of management, the bigger hurdle is the instance on the left, or the right, sorry. And on the right that's really where we start to get into this concept of legal water availability. Even though there's not this direct connection, we believe that these wells are getting their water from somewhere in the basin. That water would otherwise have discharged to the creek, and that creek's closed. We just can't put ourselves in a position to say we think that water is legally available there because of that issue. So what does this mean in terms of on the ground? What is a restricted area? What do those look like? What is it, how does that affect you as a landowner? This is just an example. We've been doing some work to refine our hydrogeological analyses in these areas, working alongside the county to figure out which areas are of particular note, where should we be focusing our efforts, because we want to provide them with additional information in areas where our 1991 studies didn't quite go. They didn't investigate the entirety of these basins. They sort of stopped with where they were able to say the shallow aquifer has an impact on the closed stream. They didn't go out and say anything past that. And so what we're doing is we're going through, I think, yeah, this is Wolf Creek. We're looking at, we're finding that the areas that they previously described are for the most part pretty correct. We've made a few little changes here and there. But we're really focusing in on these areas down here. So after you get out of the upland areas, you're getting down on the Methow Valley floor. We're finding that in a lot of cases, and this isn't going to be every case probably, but that's why we're doing the studies. For instance, in Wolf Creek, we found that once you get down to a certain point below this restricted area, which is, we'll say that the previously described area in this map is the restricted area where all these issues I just talked about would be in place. But downstream from that, and elsewhere in the Methow Basin, outside of a restricted area, you may be in a situation where your well is actually not having any impact on the closed stream. Your impact might be to the main stem Methow River. So in this case, Wolf Creek, we found that that was the case. After you got kind of down onto the alluvial fan, down by the Methow, we saw that the creek took on somewhat of a perched condition, that the regional kind of local aquifer water table there was at a level consistent with the Methow River, and that you weren't inducing flow from the closed creek by drilling wells in that area. So that's what we're doing. We're going to be looking into more of those areas. The intent there is to really figure out where these restricted areas apply and where they don't. We want to have the best available science that we can to be able to support the county in being able to make their determinations of water availability. And so we're going out into the field and we're checking stream flows. We're looking at well logs. We're going out and physically looking and locating the wells. We're going out and physically looking and locating the wells so we can get a robust understanding of where is it at a point in the basin that a well drilled is going to have an effect on that stream, and where is that stream going to be unharmed and that water use can be debited from the single domestic reserve established in rule. From the single domestic reserve established in rule. We have an obligation to do that. We want to make sure that nobody with a senior water right is harmed. We've got stream flows that are set in rule that we have to manage to, and so if stream flows aren't met, we start curtailing people with junior rights. But we also know that development is real. People have a desire to develop properties. They have desire to develop properties. They have dreams about where they're going to put their home and why. And so we want to be able to continue to do what we can to both manage a resource as well as move forward into how do we allow some things to move forward responsibly and legally and in a way that is protective of the resource. So, a couple things that we want to do. We Ecology, we're going to continue engaging with the community and with stakeholders, Watershed Council, the county, all those folks in water planning. In water planning, the council has their Water 2066, which is intended to kind of look comprehensively at what's going on with water in the Methow Basin for the future. What do we need to do? How do we need to change things or address things? That's a great effort. I do. How do we need to change things or address things? That's a great effort. I support that. Working with the county on comprehensive planning to make sure we have some alignment between land use and water use. And finding solutions for the restricted areas. It's not going to be easy. I won't sugarcoat that restricted areas. It's not going to be easy. I won't sugarcoat that and lie. These are difficult areas to work in because you don't have a ton of options. But there are some creative solutions to be had out there. We're talking at conceptual levels about what does mitigation for these impacts look like? What are those about? What does mitigation for these impacts look like? What are the other options for the county moving forward to allow building in these areas? In these areas, a very important note, if you're currently a landowner in one of these affected areas and you've got a house, and you're currently a landowner in one of these affected areas and you've got a house and you've been using your water, something happens to your well, we will absolutely talk to you about a replacement well. That's a different scenario. So if you've established a use, you've demonstrated that there is sufficient legal use. You've demonstrated that there is sufficient legal availability there. And we want to continue to assist the county with the technical assistance they need to make those decisions, both in terms of the continuity and legal availability, as well as if your property happens to be availability, as well as if your property happens to be on the margin of one of these restricted areas, and county when they're looking at that water use or potential water use to say, yeah, we think with a good amount of certainty this or that. That's certainly something that we're that's certainly something that we're there to provide. So we're going to continue doing that. So just to wrap this up and close, I just want to reiterate again that this is a real issue, and I appreciate everybody coming out here and talking with us and being willing to listen to me drone on and on about stuff. But I'll go back to what I said earlier. There are solutions to be had, and they're going to come from the community. This isn't something that I feel like one entity at all is going to be able to just reach in and fix. This is complex. This involves law. This involves policy. This involves science, and we need to all come together as a community, as stakeholders, working with the county, working with the watershed groups, to figure out what the options are. It's going to look different than it was in the past, but I'm pretty hopeful that there's something out there that we can move forward into. So thank you.
Okay, thank you, Trevor. I know this has stimulated a lot of questions. And Trevor also took a little longer than I had estimated, so we're going to cut the break shorter. So, a couple things. Write your questions. Bring them back to Sarah at the back table. Do it sooner rather than later in this 10-minute break, so we have time to sort of consolidate the questions. But before we take the break, Trevor mentioned a term which is probably not familiar. There are probably a lot of terms that weren't familiar to folks. But one in particular was Water 2066. And this is something that the Watershed Council has been thinking about and about to launch. And I just wanted to give Gregg an opportunity to spend a couple of minutes on what that is, because like Trevor said, it is meant to be part of the process that the community can work through difficult water problems like this.
Well, I need to set up the bill because everybody's got to go use the restrooms, and now I got to get this done in a hurry. We've been doing this. We've been thinking about it for about a year. Stay tuned. We've been thinking about it for about a year. Stay tuned. We have money available now, and what we're going to do starting this summer is we're going to have a series of community workshops, actually 2 of them. And the whole idea is this. We said we need to ask ourselves the question. And the whole idea is this. We said we need to ask ourselves the question, what do we want our water supply to look like in 2066? I mean, that's a real question because we're going to have more people and less water. So how are we going to handle that dichotomy? How are we going to handle the situation that our water regulations don't match our planning regulations? That our water regulations don't match our planning regulations. How do we want to see this? How do we want to see this? Excuse me. And we can give good advice as a community to the people that can actually make those changes. We're going to hold our meetings. We're going to consolidate the results, and then we're going to work with experts, and they are going to come results. And then we're going to work with experts, and they are going to come up with a series of recommendations that the community can grab hold of and believe in. And then we are going to take those to the agencies and organizations that can make a difference. And we know that if we go with those recommendations, with the community behind us, these are elected officials, and they're going to listen. So that's what it's about. Stay tuned. It's coming up this summer, and we hope to see you all there. Thank you. Now we can take.
Okay, thanks, Rick. 7:35. We'll reconvene with the panel. Okay, thanks, Rick. 7:35. We'll reconvene with the panel. So panelists, if you can come up. Yeah.
That's too bad that thing doesn't pick up the
It's the lighting. The lighting is so dim and that is so bright, it just washes it all out. It's too bad. Here?
How are you?
Good. Here?
How are you?
Good.
How are you? Good. I think. Well, pretty good crowd. Yeah, you know, this is kind of a different crowd than I don't know many of these folks. You? I bet you do. Yeah, I say I know most of them. Is it landowner, developer, rancher, farmer? Yeah, all of them. Yeah, farmer. Yeah, all of them.
It's just a device to connect to the internet.
No, there aren't. So this isn't the typical. Right.
Yeah, no, it works pretty good. There's 6 people watching.
Oh, no, I think Jason and Jeannie are here. I see Jeannie. Oh, yeah, Jason and Jeannie are here. I see Jeannie.
Oh, yeah.
Where the Conservancy is represented.
Yeah.
That's so cool.
And I'm sure the Citizens Council is
Yeah. Oh, he's so cute. Did you see a picture? The picture we got.
When we're built on the system.
Oh, okay.
When we're built on the system.
Oh, okay.
Yeah.
Oh, yeah.
Yeah, they
when
were
he
water
asked the
getting
question
ready.
about visiting.
They were getting all cleaned up, ready to go.
I suppose.
Oh, yeah, that's good.
I'm not sure the picture we can shape, he said.
Yeah, well.
I'm not sure the picture we can shape, he said.
Yeah, well.
They weighed him at his 8-week check.
Community will get involved. But it's never easy.
Well,
Well, whether you like it now or not, you know, it's an issue.
anyway,
Oh, yeah.
at 8 weeks he was 20
Well,
and a half.
I mean, we've been,
So that was, at 8 weeks he was 20
well,
and a half.
I mean, we've been
So that
rattling
was,
the tambourine for, 15 years. But now we are
really good.
getting to the
Oh,
point
yeah.
where
Oh,
it's
my God.
impacting
He
people.
ran a rig into his head and
this
all
is
over the
good.
pasture in the snow.
Well, it'll be a test of our community spirit here. Well, it'll be a test of our community spirit here.
I don't know. I mean, I think there's an opportunity for folks to get involved and make a difference.
He doesn't, he just gets
But you know, I
right
mean,
in
it
there.
really,
I gave
it's interesting.
I'll put a bow.
You got,
Little
you
Leo
know,
went up
developers.
there.
It's interesting.
I'll put a bow.
You got,
Little
you
Leo
know,
went
developers,
up there, tried to take it, tried to take
want to
it.
develop their land. You got people with existing water rights who say, wait a minute, you know,
Yeah.
what is this guy protecting?
But,
You know, so,
Callie
it's going to pit people who might otherwise have common interests against each other. Yeah.
Well,
People who might otherwise have common interests against each other. Yeah.
well, you know, it's pretty interesting. I mean, really, the most heavily impacted area is, you know, the lower valley.
Yeah.
I mean, most of these closed basins up here.
Yeah, 'cause they are.
I mean, that's just not where the concentrated development is.
Yeah, 'cause they are.
I mean, that's just not where the concentrated development is. We call it south. You know, for future development and for
I don't know, I'm in
existing lots that haven't been, you know, developed with people.
It's all those 1 acre lots that people speculate on. It's all those 1 acre lots that people speculate on.
Oh, yeah. So we'll see. I mean, you like to see the county step up and say, well, clearly we need to take a hard look at planning. And I just don't see that.
Hasn't happened yet.
Oh my God. It just seems so simple.
Well, it's scientifically simple, but politically difficult.
Yeah, it's tough. I think these commissioners know that they have to be here. All right. Good to see you. You too.
Whoever is best,
No way, man. Not knows me better.
Okay, folks, we're gonna get started. Okay, thanks for a lot of excellent questions. And we have about 50 minutes, so we're going to try to ask questions that have general appeal, not your individual property, but like Trevor said, another maybe more effective approach to dealing with a individual question is to contact Ecology through their, as they call, customer service. That's right. Right, and he has forms and cards back there. We also are going to limit questions that are very much to the topic. There were some questions that were certainly water related, but not so much about restricted areas, enclosed basins in the Methow. So if you don't hear some of your questions, those might be the reasons. Okay, so the sort of main categories of questions are, one is kind of, how did this really come about? You know, was there somebody about the zoo ecology? Was there political pressure? That kind of thing. A lot of questions about existing wells. And Trevor touched on a couple of examples, but I think there are other questions that will come up about how ecology and the county will look at folks that have wells. Some questions around that. We're also going to have questions on mitigation and solutions. You know, if you're facing an impact from this, what are some solutions? Questions about the future. Can the rule be changed, for example? And questions about future planning, links to the comprehensive plan. Those are the general categories. So I'm going to start out not how this came about, because in some ways that could be get into more sort of political speculation and slinging. I don't think it's the most constructive. We'll get back to that one though. I think for folks that are in these areas and have existing wells, they're concerned about, for example, if they have not lived or used this well for 5 years, and they decide it's now time to occupy the residence, is there going to be any issue? So, I'm sorry I didn't introduce the panel. I mentioned at the beginning who they were, but let me do it a little more formally. This is Andy Hovers, Commissioner, Hutton County, Methow resident, and the county's representative on the Watershed Council. This is Travis Thornton. Travis is a real estate attorney and a former life a water attorney, but he's not here to really represent as a Washington water attorney, but as a citizen who's pretty well informed and quite concerned.
And on the Watershed Council.
And on the Watershed Council. Natalie Cooler is a water attorney practicing out of Winthrop, and not on the Watershed Council, but on one of the committees, I believe. And then you've met Trevor. Okay.
And I'm not on the Watershed Council either.
So, could you speak to the concerns of the existing of a person who lives in these areas with an existing well that either has not been used for a while, may fail in the future? I think there were a whole bunch of questions, folks that are expressing concern about their ability to have water in the future. You know, from the county.
Well, I was going to say, are you looking at me or am I looking at you?
Well, I think the county has part of the answer, and ecology is.
Yeah, I'll try and set you up.
Oh, good, perfect.
In a good way. I think you have to look at the triggering action. If you're not drilling a well, if you are not requesting a building permit or a short plat, there's really no action to take it. And I'm assuming the case where there's a house and they've got a well, so you know they don't have a building permit need, they don't have a well need, they're just living there sometimes and not other times. That's not something that I would anticipate ecology having an action on in terms of legal water availability. But I'll turn it over to you. Anything from the county's perspective?
Well, if you have existing beneficial use, if you put your well to existing beneficial use in these closed areas, that is, I mean, if you need to replace your well, we're going. The assumption that I've had now is that the well is going to be able to be replaced.
Yes, constructed into the same sort of source that they were originally constructed. Yeah.
Can I ask a clarifying question? So what if you have a well, but you don't have a house?
That's a very different situation because it hasn't been put to beneficial use. And so if there has been no beneficial use, then again, there's nothing to rely on in the county making a water availability determination. Okay?
That's correct.
So one question was worded like this: what is the likelihood that an existing approved and legal well in a closed basin could be deemed unusable? Under what circumstances? It sounds like there's one right there. It hasn't been
put
hooked
to
up.
beneficial use.
Can we parse that? What if there's no house, but they have had a pump in their well and they've, let's say, been irrigating? It's keeping some grass wet up there.
You're getting into a legal realm that I'm not. Beneficial use is there are different types of use. So domestic use, that would have to be looked at pretty closely. It was put to beneficial use, but the use would have to be looked at closely by the county to see what was really going on. If you if you had an RV there and you were running water into your RV and you were doing the dishes and you were doing, taking a shower and everything, that's beneficial domestic water use. You would, in the county's under the county's kind of guides, you would be able to build a house using that well.
And further, the irrigation use would not have the same priority as the single domestic use. So, even if you had established some irrigation use, there's a chance that the county would need to look at whether or not that was even reliable in the first place, and the question of can you change a permit exempt use from one to another. Lots of cans of worms to be open there, but Andy's right. I mean, the purpose of use is important, and when you establish a use for domestic purposes, that means something different than establishing it for some other purpose.
So to be clear, you don't consider the family of exempt uses to be a beneficial use?
A benefit?
House, stock, water, irrigation.
I would further clarify that as a beneficial use for a qualifying purpose.
So I guess what this means, just to back up, there is a category of beneficial use that means you are using a water right for a legitimate purpose. And then there are subcategories to that. And there are a variety of different subcategories, and one of them is domestic use. And so if you establish domestic use through an RV or through a prior house, you're good to go. If you don't.
Right, if I drilled my well and I have been watering stock out of that well for years and years and years and years, and all of a sudden now I want to build a house on the well that I was watering stock from, that is not the same type of use as the domestic use.
To be clear, the question was asked here: if a well was installed properly in bedrock at the time, before this change in interpretation, if a well was drilled and approved by ecology, sealed and into bedrock, is there any likelihood or any reason, if it's being put to beneficial use, that could now be in jeopardy?
If it's being put to beneficial use for domestic purposes. Right.
Is that safe?
Do you want to answer the question? Could it ever be? You can't ever answer the question. No, absolutely not. There isn't. It could never be in jeopardy. But as of right now, the way that we're looking at things, that well would be able to be used.
Yep. Yeah, we're considering that established uses are established uses. All the points I talked about are basically from December 4th onward, not something prior to that. So those decisions were made.
So the agency has always taken a prospective look, right? When you're making these changes along the way, you're not going to reach back and take things away that have been previously granted.
Yeah, that's certainly not my intent.
At the court level, though, there have been circumstances with, as a result of litigation, there has been retroactive effect. That's entirely outside the agency's control, but it is within the realm of possibility out there in the world if you end up in a litigation situation.
That's a great point.
And that's why I said that you could never answer that.
Yeah.
A related question to the one moment is that if a landowner was to lose the use of their well due to some action by ecology, the courts, the county, whatever, how will they be compensated?
So, number one, we're not reaching back. So, anything right now that was put to beneficial use, you have a house on it, there's no reach back on it. I mean, that scenario right now only exists in a situation of litigation that has not happened yet.
And I would also say that ecology has enforcement discretion. You know, a use can be, let's say, outside the bounds of the law, but we can recognize the hardship facing folks. You know, there are instances in other parts of the state where this sort of thing has happened, and that doesn't mean we're going out with a bulldozer and tearing people's houses down and kicking them out. It means we're especially invested in those areas, trying to find solutions to make things right again. You know, we're not going to bring the hammer. We're going to try and bring solutions whenever we can.
The other thing I would say about that is that that hopefully we would be able to, and we're exploring mitigation options right now.
And we are going to have some questions on that.
But I'm going to go to that first. You know, if you ever had something where, you know, in that case, I think that every option would be looked at as far as how can you mitigate for these people who might lose this use.
So a related question to that is, how will landowners be compensated, not for the loss of the use of a well, but for a perceived loss in value of their property if they're in these closed basins and they cannot put a well
I guess that's the risk. It's hard to say this, but if I bought a house in 2005 in Phoenix, Arizona, that was worth $600,000, and in 2008 it was worth $300,000, who was going to compensate me for the loss in value of that house? Who did compensate everybody who lost that much value in those houses then? They weren't compensated. It's a risk that you take when you purchase something. I know that's hard to hear, but it is. So now, though, again, as a county and as the DOE, we don't want to have, I don't want to have people lose value in their property, lose value in their houses, you know. So we are looking at options to keep people's property values, you know, worth what they are through mitigation efforts, even though we're not being able to drill wells. What are the other things that we can do to get people water?
So I think to me these questions really highlight kind of the key issue, which, and Trevor touched on that a little bit as well, but that's, you know, that's why that potential loss in value is in part why these public meetings exist and everybody's going out and informing people that this is happening, because you do not want to buy a property that you think you'll be building on and then it turns out you can't, or at least you can't right now. I don't think that there is an avenue right now, an easy avenue for compensation. You know, I guess legally you tried to argue maybe, I don't know, building permits were issued improperly. I don't think that would fly. So unless there's a political solution, I don't think there's a, it's certainly not as though, you know, there's a state fund available for compensation in these matters. could argue this has just been a risk all along, and now you know it, and now you're preventing us from stepping into it further.
And I heard the question be like raw property, that's what I understood the question.
Yeah, the question related to loss of value of property because it can no longer
Drill the well.
have a well. Yeah. So I'm gonna, before I move to questions in another category, which is a little more about the science, is there any clarifying question on this particular category of existing property owners and existing wells? Just quick questions. Is that what you're?
Yes.
Yes.
Is there a time frame on wells being put to beneficial use? Does it have to be used within the last 5 years, last 10 years, or could I have used it 20 years ago, stopped using it, and now start again? We're all smirking again.
Well, we just had this discussion.
Yeah, we talked about this a little bit ago.
Yeah, we did. I can't offer legal advice, but I would say if you put it to beneficial use, you put it to beneficial use.
Okay. No time frame. Just.
I can't say no time frame because I don't know.
That is an unresolved, let's just say it's an unresolved issue.
Yeah.
There are strong opinions on both sides of it, and it has not yet been tested.
And not just here,
Not just.
all around the state.
Any quick question on existing wells?
Yeah, this goes to the question of compensation
Okay.
for those. And I think it's a rhetorical question. It wasn't my question. But I think it's a rhetorical question because what happened in Phoenix, Arizona and throughout the Southwest was a market-related event. This is a government event. Essentially, the government taking away the right to develop the property. And so then there's a sense of outrage about that, and what about me and what about my property? And I think we all know there is no fund. You're just out of luck. But I think there's a sensitivity to that of being taken away by government.
I do too.
And I don't sense it's being taken away by Oklahoma County, right? It's a state issue.
It is a state issue, and through lawsuits, through litigation, through a rule that was written back in 1976, the year that I was born. Okay,
Yeah.
it's, that is the reality that we live in today. Now, can we fix these issues? We might be able to.
Well, that'd be great. I feel for all those people who are going to lose, but it's
Well,
a rhetorical question.
But I know, but you say that they are going to lose. Yet I am on the opposite side of that, and I'm hoping that no, they don't lose. That we can come to. I mean, right now. We're talking with the county commissioners are de facto on the public health board and talking about changing the health code in Okanama County to allow for cistern use here. Okay, so if you can put in a cistern, okay, then you can, and we allow it to be potable water, you can build a house. So those are the types of ideas that we're thrown out there. I mean, there's a couple other ones that are, have some more legal issues to kind of work out, but we're not just, Okanama County DOE, we're not just sitting there going, well, too bad this happened. We're trying to put our heads together and say, okay, how can we fix something that was created not of our doing, but through a lot of other things that went on.
That's great.
Yes.
What is the difference between drilling a legal well prior to December and beneficial use on it? Once you make that well illegal, how can you have beneficial use on it, which I think is great, but why not allow all of the wells that were drilled in the old interpretation to stay and then change the WAC or the interpretation from this day forward?
So a couple things there. I'll start with the last thing, changing the rule, which I think we're going to have some more questions
We
on
have some
later.
questions.
Why don't we just do that? It's a very, very complicated process. It's contentious. You know, if you open up the rule, you have to be aware that, you know, you might petition to have it open for one reason, and other people come in with their needs and wants, and you know, we're going to have to.
Simple enough to change the rule. I
We'll
understand.
get a little deeper into
Would you
that.
mind answering the question
First part.
about why not allow all the wells that were drilled with in compliance? Why not just have those be legal wells?
It goes back to the point that Andy and I were talking about, whether or not they had established a beneficial use. Until you've established a use, you don't have any legal right to that water.
But you wouldn't have a legal right to illegal well and beneficial use.
So I wouldn't classify the well as illegal. The well is just a hole in the ground, unless it's illegally constructed, which is a separate matter. But the well itself isn't the issue, it's the use. And so the thing that we are talking about is whether or not you've established a beneficial use and whether or not the county can rely on that for making their building permit land use decision.
So kind of a practitioner's perspective on this is you're hitting on the very issue that a court might look at and say, yeah, all those past wells you put in since the 1991 change, they're no good either. Right, and so to me, what ecology is doing in terms of saying, okay, we're not going to go back, is probably kinder than what we'd get. To go back is probably kinder than what we'd get if this were to go to a court decision, because I don't think a court would have that regulatory enforcement flexibility. So yeah, I'm not sure that there is a legal reason. It is simply, but it is a reason that is more flexible than what we might otherwise get.
Sort of legal.
Sort of legal, yeah.
But
And it's fair, more fair too, right? Because if you've already put in all that money and built a house and all that, you're facing a different kind of financial situation or financial hit.
Yeah, by degree.
Trevor? And I was going to say, just as it was alluded to at the beginning of this, the way these things are being pressed on over time is because there's just more pressure on the resource. And so you look at it from the side of the water right holder, the senior water right holder, is being impaired as a result of the cumulative impacts of the number of these wells that are being, and that's what happened in Whatcom County and Hearst. You think that my little domestic well that I'm only taking a few hundred gallons out a day is not the thing, but what happened in Whatcom County is that there were so many of them so close together all at one time is that it was actually having a physical, noticeable impairment on senior water rights. Senior water rights weren't getting their water as a result of the cumulative impacts of all these exempt wells. And that demonstration of that loss is sort of what started to lead towards that conflict. And so if you look at it from the other side, if you haven't been using it to date, how are you entitled to use it if it's impairing the water rights that are senior to you under the priority system?
And Travis brings up a good point in that somebody asked the question, well, what about my perceived loss of value? If I had a 1974, 75 water right from one of these creeks, a surface water diversion, and I wasn't getting my water, I could call every single house that had a well in that basin, and I could say, you guys can no longer use your water out of your well because I'm being impaired. So you know, that's the extreme, but that has existed in Western water law forever. So, you know, if you think that, oh, well, I drilled a well and I'm okay because it's my water in my well, it's not. You know, if I can prove as a senior water right holder that your wells are creating issues for my irrigation rights, I can just say, hey, everybody's impairing me. Now, is a person going to do that? Probably not. I mean, that's why you probably have never seen that happen even though there are people getting impaired that could call every single well in probably this into this whole basin, because they're just junior to or just senior to most of the wells that they use.
So, I know there were some more hands, but I want to honor the process of written questions, and also note that with less than a half an hour, we really want to hear about solutions, mitigation, how do you solve this problem, and there's some questions about that. So, but just a couple of little technical clarifications that were asked, which basically, are you saying that under no circumstances can I drill a well of any shape or form in a closed basin restricted area? Now, through bedrock to the center of the earth.
So that's not quite what we're saying. We're saying that if you have an existing use that you need to drill a replacement well for, we're certainly happy to work on that for you. Other than that, there are going to be very, very few instances, and I want to stress kind of how high the bar is here, to be able to construct a water system that would be eligible. I think it would take a lot of work, it would take a lot of consulting, it would take a lot of previous consultation with ecology. If that is something that you think, well, the sky's the limit, I'm going to work with all these hydrogeologists and I'm going to get my own independent study done and I'm going to prove that this isn't an issue to me. I would just strongly urge that you contact us, because we can provide technical assistance as to sort of what are the things that would get us to look twice. It's a really high bar. I'm not going to lie about that or sugarcoat that. That graph that I had on the right, you have to presume that all the water that's ending up in these wells is coming from somewhere in the basin that otherwise would have gone into a closed creek. And again, it's closed administratively all year round, and we have an obligation to ensure that no new consumptive impacts would affect that creek.
One other clarifying question, are such maps forthcoming?
Yeah. Well, they are, yes, and you can call the Oklahoma County Planning Department, and they will look at the parcel and tell you. Most of the time, they can say either you're in or you're out. If you're on the line, it may take a little bit longer because we'll probably have to get more information from ecology. So you can actually call over, give your parcel number to them, and say, hey, am I inside of the restricted area or outside of the restricted area? Now, there's 5 that have been redone so far right now, I believe.
Yeah.
So there's 5 of the 15 closed.
Three formally. We haven't officially sent you the letter yet on the other two.
Have the others.
Yeah.
So in a little bit, there will be 5 that are officially done. And then the other, if you're in one of the other ones, it may take a little bit longer because we have to make sure of we got to do some analysis with ecology. But for the most part, if you call, we can let you know where you're at.
Andy, the Wolf Creek map that was done in 2017 by Ecology,
Yep.
Does that remain in effect, or
Yeah,
is that
absolutely.
changed?
No, that one was the first one done. We had 5 houses going on that were being challenged because they were in a closed basin, and luckily had a lot of information that was gathered there, and so that one we needed done. That one got done, and it was the first one, and now there's 4 more after that.
Great.
So yeah, if they were revised after post 1991, then those are the maps that we use.
Okay, to get into the mitigation and solutions part here, here's a interesting hypothetical situation. If you assume that 90% of domestic water is recharged back through the septic system, if a homeowner was to truck in that 10%, whatever that volume was, monthly, measured by metering, would that be an acceptable solution to ecology and the county?
Wait,
in other words,
I didn't understand that. Truck in the 10%.
Oh, so
offsetting just the consumptive.
Offsetting the consumptive use, allowing a well to go in, assuming that 90% of what the well pulls out goes right back into the ground, the other 10% is trucked.
Pump it into an infiltration gallery, basically,
Yeah.
to mitigate for the use. That is something we'll explore.
Yeah.
Absolutely, that's a really good idea, actually.
We've been talking about that sort of thing through one mechanism or another. We've got some pilot projects in a similar sense going on in Kittitas County. So, certainly that's on the list of things that Andy and I have been talking about for a while. We'll just need to figure.
I'm going to say that with.
And as you start scheming about this in your own mind, think about where you're going to get your 35 gallons a day from. You're going to get it from a rancher? Well, that's day from. You're going to get it from a rancher? Well, that's a change of use from that irrigation water to another use. That irrigation right's not any good in the winter. You're going to get it from the towns. They're going to have to agree to sell it to you. They're not going to sell it to you. You're going to get it from your own domestic well, from your other property. Well, that's a change in use of that water too.
And you can't change it.
Yeah.
But you can get it from the river.
Or the beer, you get beer, right? You can bring beer in.
That one actually was already brought up. So there is a way to do it now. Because you can get water for, I believe there is a way to do that, actually.
What's your thinking? I think this.
Well, because the 2CFS reservation is for single domestic use, and that's the water is for single domestic use. So there's a lot of stuff going on about the pumps and pipes and everything else, but it is the water is for single domestic use. And as we were talking about earlier, that water contained in a container is, even though it's multiple it's hard to explain.
Can I try a different route?
Yeah, you can. Absolutely. Absolutely. As soon as you shook your head yes, I was like, okay, good.
Well, because there are permit exempt uses for commercial as well. So whenever the Methow River in-stream flow were not met, you could perhaps use the commercial exemption to sell water commercially to those folks who need to truck it up into a closed basin and offset.
Commercial, you call yourself stock.
No, just the general commercial use like the.
So you can see we've got all this ironed out already.
Yeah. But we are thinking about it.
So if you are thinking about using the single domestic main stem reserve to offset the restricted basin use.
Remember.
Why can't you just allocate that reserve to the next sets of applications until you've used up your reserve?
Because that's a change of rule, and we can't. It's too hard to go through.
You can truck it, but you can't allocate it.
Yep. Again, this rule was created in 1976, and it was created under a surface water diversion. It was everything. All the auspices of this rule were surface water diversions. Ecology was worried, or the people that actually kind of started this were worried because for surface water diversions, I could have gone to Ecology and asked for a right for a surface water diversion for potable water for a 200 bedroom motel, and they would have needed to look at it. So that's correct. Okay, under the groundwater rule, 1945 groundwater rule, you're limited by 5,000 gallons a day, but surface water diversions, you were never limited to the amount of water you took out. That was the big difference, and that's why, had this rule been written more around groundwater, that the single family and group domestic probably would have been lumped in the same category, and obviously I'm speculating, because there's the exact same 5,000 gallon per day maximum usage on it. It was not, hey, somebody's going to come in and build this huge motel, and they're going to ask for a 1 CFS surface right to fill their giant cistern. So the 2 CFS is it's not just necessarily main stem. It covers the entire reaches.
Well, that's what I thought.
So to me, that's the
upper trips.
That's the key, exactly. The 2 CFS applies everywhere, but then that's the base layer. And then in these where you have closed tributaries, closed surface waters, you have another layer on top of that restricts that 2 CFS. Right, so the ultimate base layer is Washington State water law. Then we have our Methow rule with the 2 CFS reserve. And then if you're in a restricted area, you're near a closed tributary, you have that additional restriction on it. And you can't take water out of that restricted tributary anywhere in that closed area. And so you can't just say, well, I'm taking it out of the 2 CFS, because you can't take it out from the top. You have an additional layer, making it even harder. It's kind of, yeah.
So what other solutions have been brought forth? We've heard trucking water.
Cisterns, pumping water from basically a well outside of the closed basin to an infiltration gallery or an injection well inside the closed basin. That one that was just brought up is very interesting. Right now, those are kind of the things that we're looking at, because the way the rule is written, there is no time frame on this closed surface water, so it's not like you can collect it in the spring and then hold it and then infiltrate it for use later. Confines of what we have.
Having said that, I think the Watershed Council is also considering whether there is a path for this rule revision as part of the Water Policy Assistance. Right, is that correct?
That is correct. But I'll also reiterate that we've been looking at rule revision for about 5 years now, 6 years, and the deeper we drill, the tougher it gets. Yes. Keep that, see.
Any questions out there on solutions, mitigation? Yeah, in the back.
With the mitigation infiltration well, how do you protect against toxins and PCBs that would be pumped into my aquifer from somebody trying to mitigate?
It would be, a well like that, created like that, would be something that was regulated like a class, basically that well would have to be regulated like a Class A water system. So you'd have to do continual testing on it. It would be more of a, I don't want to say a county run. I mean, we have county run, water systems here in the valley right now, or county operated. But it would definitely require more monitoring than just a regular well. This wouldn't be just, hey, this guy over here gets to go drill a well and pump it over. It would be, this is a system that will mitigate for the basin. And so, so now how are we going to operate that system?
I'm going to punt a little piece of this question over to Mark Schuppe, who's got some experience in similar issues.
Yeah, I've been involved with several restorative and recovery projects, and you're right. The water that we inject into the aquifer is one of the biggest stumbling blocks. The water has to meet the groundwater quality standards. Okay, and most times they don't, and we have to go through what's called an OPI, a ready public interest test. But even then, it's not like we're just going to ignore the groundwater quality standards. We may allow some slight exceeds of standards, but still within safe drinking water act standards. So things like PCBs, we would never allow those to go into a well for an injection project.
Why not put it in a septic system? It's only 10%, 90% is going through the system, just put it into the septic system.
Yeah, flush it down the toilet.
Shallow infiltration versus well injection.
Yeah,
I think there are separate, I'm looking over at you like you know the answer, maybe you don't.
What?
Are there separate conditions and requirements for an aquifer injection versus like a shallow aquifer recharge where you're essentially distributing it into the soil?
I actually don't know. The projects I've been involved with are aquifer storage and recovery projects. And usually the biggest challenge there, because it's mostly municipalities doing this, is disinfection byproducts. And they typically result, when you close to an aquifer, typically results in the formation of trihalomethanes.
I think what all of this gets at is ultimately any of these solutions will have to comply not only with water rights law, but also with all kinds of other environmental regulations. And that is a whole additional issue that we're going to have to wrestle with as we try to figure out what the best way is to mitigate.
So that's a good segue to the next small group of questions, which is about sort of future planning. And the comprehensive plan that the county is in the process of updating now. It came up several times. Here's a great question. This will make you think. As we move into the comp plan, is it better for us to think of it as an aspirational process that is reflective of where we'd like to be, but assuming a future change in in-stream flow rule, for example, or as a realistic process, reflective of the current legal landscape, assuming no future rule change?
Was this question for me?
Question for the politician.
It was a really good question, and it does make me think, because right now under the current rule, if we were to say, okay, if you were to do real comprehensive, if you were to take a hard look at the comprehensive plan and how it relates to the Methow Valley, okay, the rule that governs water does not allow for increased municipal use. So the water that we have is out in the county. Okay, so when we're talking about water quantity, the only place that we have water for people to build is out in the county, right now, under the current rule.
Well, the towns still have water.
Okay,
We still have
so based on a 50-year planning horizon, they may still have water, but can they get any more? Okay, so it becomes, do you plan for what could be or what is right now? That's a really hard question, because for the county for the cost of services, obviously it's better to have people localized around the the hubs. Here at Winthrop, Twist, with them, not so much, but you have to have the water to serve the people. So in reality, right now, you plan for what you have, not what you think you can get, because you don't know what you're going to get, in rural regions.
And that's why planning is iterative, not one and done, right?
Right, that's right. That's why at any point in time, people can open up the comprehensive plan and say, in fact, I think, Kittitas County charges $1,000 to open up the comprehensive plan.
Does that cover your costs?
No, not at all. That's as good of an answer as I can get. We try to plan for what we have right now, because I cannot speculate on what's going to happen in the future as far as rules and laws.
Travis, you.
Again, it's more of a plug for Water 2066, because I think the comprehensive plan is going to result in a vision for land use in the valley that is not enabled by the current body of water law that we have and that we're dealing with right now. And I think everybody agrees that the water law could be modernized to a more progressive vision of what land use in the valley, what the people of the land, the valley want the land use patterns to look like going forward, and the comp plan is going to reflect that. And so the next task beyond that is to look to modernize the body of water law regulations to match the vision as embodied in the comp plan. So the comp plan should be, what do we want it to be? And then we figure out how to fix the politics of it to match the vision.
But I can tell you right now, I don't think there's a single comp plan meeting that has had this many people in the audience, right? So it's a plug for getting involved in the comp plan perhaps as well as.
Yeah. And how does one do that, Andy?
Our agendas come out every Friday. You can check our agendas, our planning agendas, when we're talking about comprehensive plan updates, and unfortunately, they're they're during the day. I know a lot of people work. That's when we're doing it. So,
Can you have one here in the valley?
that's a good question. I mean, yes, obviously, the answer would be yes, we could.
Do you have it for a long time?
No, and we're out in comment for, yeah, let me think about that.
That'd be really helpful. I think you could fill a room if you had it, and if town didn't have to try it a little week to talk to you.
Trevor?
So I just want to add on to that, the comprehensive plan being very important. The other thing that's very important is the more that this community and this group of interested stakeholders can bring products like a robust vision in Water 2066 and a comp plan that everybody's standing behind, and rallying the support of all the stakeholder groups, whether that's people who are more for development or less for development, more for the environment, less for the environment. If you can find a way, and I know that's kind of tall order, but the ability of a group that has that broad-based support to come before ecology or the state or their legislator or somebody to say, hey, we've got something in hand that we think works for our community. How can we make that happen? That's going to get a lot more traction than if we're hearing one thing from one group and another thing from another group, and the third group won't even show up. I just can't stress enough, in finding solutions, it's so vital and so important that you're inclusive, you're bringing a well-rationed, well-thought-out project that whether it's a legislator or ecology or whoever can say, I get it, this is something that you guys have obviously thought about, you've obviously been through the ringer on, have you vetted this, have you put all these things through the lens of law and policy, and you know what you really want to get out of it in the end. So.
Okay, we're out of time, sorry. Trevor and the ecology folks do have their contact information in the back. The Watershed Council talks about this, and will continue to talk about this as long as it's relevant. And so that's a source to see what's changed. And of course, the comp plan and the Water 2066 are other opportunities to be involved. Thanks, first of all, to Ecology, Vanessa, Mark, and Trevor. And to our panelists, Andy, Travis, Natalie, thank you.